And we have breaking news. A judge in southern Illinois has overturned the so called Illinois assault weapons ban and magazine ban. And yes, that happened just hours ago today. I have good news for you folks. Long anticipated news regarding Illinoisans and their Second Amendment rights and what is about to happen in a few short weeks. We're going to get into the article here in just a moment, but be sure to subscribe to the channel, share this video, comment your thoughts in the section, and share the video as we let other people know it's time to celebrate. Or is it? So we have out of Fox 32 Chicago, a federal judge on Friday, earlier today, overturned Illinois' ban on semi-automatic weapons, leaning on recent U.S. Supreme Court rulings that strictly interpret the Second Amendment's right to keep and bear firearms. U.S. District Judge Stephen P. McGlynn, by the way, you may remember in previous videos when the Illinois assault weapons ban was coming about, this judge had been heavily involved in the past. Anyways, Judge McGlynn of the Southern District of Illinois issued a permanent injunction he said applies universally and not just to the lawsuit's plaintiffs. He decided, however, that the injunction would not take effect for another 30 days. Illinois Attorney General, our lovely Attorney General, Kwame Raoul, responded speedily, filing a notice of appeal earlier this evening. The Protect Illinois Communities Act, signed into law in January of 2023 by Governor J.B. Pritzker, isn't he lovely, took effect on January 1st, and it had banned AR-15, AK-style weapons, magazines, standard capacity magazines, and an assortment of attachments largely in response to the 2022 Independence Day shooting that happened in the Chicago suburb of Highland Park. The opinion drew heavily from recent landmark Supreme Court rulings expanding on the definition of the Second Amendment and its guarantees. Sadly, there are those who seek to usher in a sort of post-Constitution era where the citizens' individual rights are only as important as they are convenient to the ruling class. McGlynn wrote in his opinion, the quoted phrase that no right is absolute does not mean that fundamental rights precariously subsist subjects to whims or appetite of government officials or judges. I'm sure that made Pritzker and old Kwame quite happy. Despite those, Pritzker said he remains confident the law's supporters would prevail. Fellow Democrat Raoul filed a notice of appeals with the U.S. Court of Appeals for the Seventh Circuit seeking reversal of the lower court's order and the permanent injunction. Despite those who value weapons of war more than public safety, this law was enacted to and has protected Illinoisans. Has it really? I mean, come on, guys. I have posted countless videos of bad guys who have not registered their stuff, who are not in possession of proper licensing that's required in the state of Illinois. Well, they just don't care. But you and I, we both know that. This law was enacted to and has protected Illinoisans from constant fear of being gunned down in places where they ought to feel secure. Should you not feel secure on Michigan Avenue, Chicago? Should you not feel secure? It does nothing. But that's just one man's opinion, of course. The governor's confidence that the constitutionality of the Protect Illinois Communities Act will be upheld through appeal. The law, written by Democrats who uphold supermajorities in the General Assembly in Springfield, Illinois, came 6 months after a lone gunman perched atop a building at the Highland Park Parade. It drew immediate scorn not only in the form of lawsuits from gun owners and advocates, but from scores of county sheriffs who said they refused to enforce what they considered an unconstitutional law. If you guys remember, elected sheriffs were getting involved. McGlynn, the judge, who was appointed to this post in the Southern District of Illinois by President Trump during his last term, drew closely on the U.S. Supreme Court rulings from the past 15 years that have solidified and more recently expanded the interpretation of the Second Amendment and its guarantees. He rejected state officials' arguments that the Protect Illinois Communities Act withstood constitutional tests because it addresses a new phenomenon, mass killings, and new technology, semi-automatic guns. While mass shootings and firearm-related deaths are universally tragic and senseless, the government has not met its burden to prove that the history and tradition of firearm regulations supports PICA, the Protect Illinois Communities Act. Expansive sweep, covering hundreds of models of weapons, magazines, and attachments used by millions of law-abiding U.S. citizens, the judge wrote. Eric Pratt, Senior Vice President of the Gun Owners of America, which, by the way, is a fantastic organization, which represented one of the plaintiffs in the case, said that Pritzker and Illinois lawmakers, that they warned them to fall in line, but they chose to do the opposite. While the case took time, we are thrilled with the victory and for the citizens of Illinois, and so am I. We, the Peep family, I'd like to know your thoughts on whether or not this ruling came soon enough, or perhaps we ought to take it a step further and try to get rid of some of these statutes that are called acts of public safety, like the FOID card. How good has the FOID card done Illinois since what, 1967? It's been a cash cow for the state, that's for sure. And a lot of otherwise good law-abiding people have lost their rights from it. So do we need to take it a step further? I'd like to know your thoughts in the comment section. Folks, my name is Paul, and I am IPAC instructor. Again, subscribe to this channel. Be sure to like and comment, share this video. As updates come about over the next month, I'll be producing more videos for you here. Folks, I love you. I thank you. I appreciate you for tuning in. It's a little celebration. I would say good enough, huh? I'll be seeing